I didn't want to be odd. What? What? I don't think that's Welcome to the Board of Zoning Appeals for this Monday, October 23rd, 2023. We will begin with Ms. Kukla reading the preamble.
Thank you. Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals. I'm going to read the preamble for you this October 23rd, 2023. In compliance with notification requirements of the city's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that calling users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on our particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who have provided written comment on a particular matter. Back to you, Madam Chair.
All right, do you want to call the roll?
Sure. Ms. Roca? Sure. Ms. Holzer?
Present.
Ms. Wilson?
Present.
Ms. Brown? Present. Ms. Bates?
I am here.
Madam Chair, we have 4.
And all 5 members. Welcome to all my board members. It's good to see everybody.
Thank you, Madam Chair. Morning.
All right.
All right, Madam Chair,
Any
we have,
postponements?
we have no postponements or withdrawals.
All right, no postponements or withdrawals. Okay, Mr. Bruland, any council people with us?
I do not see, let me do a quick check again, but, no, I do not see any council people with us
All right,
so far.
so far.
We do have the chair of the Landmarks Commission here, if you would like to take him first.
I think that would be a very nice thing to do.
Oh, no, he is first. The first.
Yeah. It's nice when it works out that way, but we are going to take the, as a convenience to the chair of the Landmarks Committee, we're going to take that case first, which happens to be top of the agenda. So Ms. Holzer, if you want to read, we're going to start with calendar number 23-165.
No problem, thank you. Our first case is calendar number 23-165. This is Brent Eisenbach's appeal of the decision of the Cleveland Landmarks Commission. Brent Eisenbach appeals under the authority of section 76-6 of the Charter of the City of Cleveland and section 329.02D of the Cleveland Codified Ordinances from the decision of the Cleveland Landmarks Commission to issue a certificate of appropriateness for new construction of Marion C. Seltzer Pre-K through 8 school and joint city recreational space at 1468 West 98th Street. With that, I will hand it over to Ms. Wilson for the oath.
Thank you so much, Ms. Holzer. I am going to swear anyone in who wishes to speak in this matter. We'll start with the people online and then we'll move to the people in person. So after I read the oath, please reply with "I do," your name and your address. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth?
I do, yes.
Richard,
I swear.
and your name and address.
My name is Brent Eisenbach of 1267 West 103rd Street, Cleveland, Ohio, 44102.
Thank you.
And I do, Dan Musson, Cleveland City Hall, 601 Lakeside Avenue.
Dan, I'm sorry to ask you this. Can you spell your last name for the court reporter?
Musson.
Thank you so much. Do we have anyone online? Okay, Ms. Wilson, I think that we've captured everyone.
Okay, perfect. Back to you, Madam Chair.
Great, thanks. Liz?
Madam Chair, this is an administrative appeal, so there's no history research done on this case.
Okay. All right then. Legal standard?
Madam Chair, members of the board, appellant is appealing the decision of the Cleveland Landmarks Commission to issue a certificate of appropriateness. Standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and appropriate evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
All right, thank you. All right. So Mr. Eisenbach, do you want to tell us why you're here? And what you'd like to have happen?
Yeah, Madam Chairman, I would like to, if possible, read the statement that I previously provided to the.
Your materials are up on the board. If
Oh.
you want to fast forward, you know,
Wonderful.
if you want to page through it forward and reverse on the presentation.
Thank you, sir. So ultimately, and I'll get to the conclusion at the end, Madam Chairman, but I would like the Board of Zoning Appeals to reverse the decision that was made by the Landmarks Commission in issuing a certificate of appropriateness for the new Marion C. Seltzer School. And I think the statement, as I walk through it with you all and show you the evidence, it'll be clear to you that there were some discrepancies made by the Landmarks Commission that should be remedied. Dear Madam Chairman, I'm writing this letter to summarize the basis of my appeal of the Cleveland Landmarks Commission Certificate of Appropriateness that was issued. It is called case number 22-064. Firstly, I assert that the Landmarks Commission issued a certificate of appropriateness illegally approving the site plan, which contradicts the approved legislation governing the development of this site. Cleveland Codified Ordinance 75-2021, Section 8 states that CMSD shall construct a practice field and outdoor basketball courts on that site in consultation with the city, and will lease those facilities to the city at the time when they are not needed for school district purposes. This is Exhibit A. So what I'm clicking through right now is Ordinance 75-2021 that was approved by Cleveland City Council. And as we get down to Section 8 here, the highlighted section quotes that, which I just read. I'll read it again. CMSD shall construct a practice field and outdoor basketball court on that site in consultation with the city, and will lease those facilities to the city at times when they are not needed for school district purposes. Continuing on in this legislation, there's an executive summary that accompanied the legislation for council members to read. And the highlighted section there again, I'm sorry, it's a little bit, I should just go to my own exhibits, right? I beg your pardon. This is the first time I've been to a BZA hearing.
Well, welcome.
Thank you.
You're doing well so far.
Excellent. So again, here in the executive summary, which further supports the actual text of the legislation, it says CMSD to construct new play fields on the current school site after it has been demolished for mutual use by both the city and CMSD. City and CMSD will also share their parking lots during non-peak hours. Next, a planning flow chart, which was produced to me during a public records request. Also shows here for the Marion Seltzer School that, as you can see here, the building of playfields and lease back existing school site to the city. So this was produced by the Mayor's Office of Capital Projects when the document was requested.
Do we have a date on that?
The date that it was produced to me was October 2nd.
Okay,
I don't have a date on the actual flow chart, ma'am.
okay.
This concept was further reinforced by multiple publicly accessible video recordings of city council committee meetings, which is Exhibit C and C1, which document then Commissioner James DeRosa, who was the Commissioner of Real Estate at the time. He's currently the Director of MOCAP. That playfields were going to be built on the site of the former school building as the post-construction condition for this concept. So the first one that I have here is the City of Cleveland Council Committee on Development Planning and Sustainability. This was from March 23rd of 2021. And at timestamp 14 minutes and 25 seconds, Commissioner DeRosa says, once the new school is built, the old school gets demolished, and then CMSD is going to build new ball fields to replace the ball fields that are lost by the construction of the new school. And those ball fields will be leased back to the city for a 45-year term at no cost to the city. And we'll have some renewals after that, and it's rent-free. And the other thing that we're doing here is that we will be sharing the parking lots at the new school and in the Cadell Rec Center so that we can reduce the number of, parking that we have and expand the amount of green space that we have. Another exhibit of Commissioner Rosa, now Director James DeRosa. This was at the Finance Committee meeting on March 29th, 2021, timestamp 31 minutes and 37 seconds. Commissioner DeRosa says, after they build the new school, they'll demolish the old school and replace the ball fields on the existing school site. They will enter into a lease of 45 years with the city so that we can have shared use of the ball field and kind of replace what they are going to be removing with the new school site. The other thing that we are doing is a shared parking agreement so we can have shared access to the Cadell Rec parking with the new school parking. And that would be a 10-year term that would renew automatically from year to year. This concept of replacing the ball fields and having a shared parking was further reinforced as recently as March of 2022. This document that I'm flipping through now was a community engagement presentation that was provided by CMSD to the community during a March 15th, 2022 public meeting. And this was produced by their architect, then design. And the piece that I want to get to is here, which is a site map, a site layout plan, which, does this have a pointer on it, sir?
No.
Okay, which as you can see at the north in the yellow area, it says academic wing. And then as you continue south, you can see the administration wing and the gym and the dining facility, which is followed by parking continuing south, which is the lower portion of the map, followed by U11 ball field on the very south end of the site. So that is the area at which the ball field would be replaced, which is discussed and passed in the codified ordinance governing the construction of the site, reinforced by the Commissioner of Real Estate, and here further reinforced by CMSD's March 2022 meeting. And going on a little bit more, I've got an exhibit from, excuse me as I click through here. Right. So this is an exhibit from that public meeting. You can see in the upper right-hand corner, this was a recorded meeting. And that is one of the architect's representatives. His name's James Cowan. He's a project designer with Then Design. And at 19 minutes and 45 seconds, James says, and looking at the site and the building again, we have some adjacencies at play that need to follow each other. So again, we have the building to the north and the parking will be to the south of the new footprint. And then below that, we have to bring in some green space. And again, we want to connect back to the swath of green, the commons from West Boulevard that goes up to Detroit. So if we can bring in that green field, that U11, that would be great. However, when CMSD's hired architectural consultant, and another exhibit here, this is currently on the CMSD website. There's segment 8, which is the latest round of school buildings that are occurring. This was a screen capture from October 2nd of this year. And it says in the highlighted sections that number 1, it'll be built just north of the school's parking lot and south of the clock tower. And number 2, a new U10 athletic field to be constructed on the site of the current school after the new school opens. So this is still a document that is actively on the CMSD's website. Again, flipping back, you can see the clock tower is at the very north end of the site, highlighted in orange. And CMSD says that the building footprint will be built south of that area and that a new ball field will be constructed, excuse me. However, when CMSD's hired architectural consultant presented the conceptual drawings to the Landmark Commission on August 25th, 2022, the plan had changed and the required playfields were eliminated. This is the August 25th, 2022 meeting of the Landmarks Commission. This is a screen capture of their publicly recorded meeting. And you can see here that the footprint of the building, which is highlighted in orange, has changed. It extends much further to the north to Detroit Avenue. It extends north of the clock tower, which is represented as a small square box kind of in the northwest corner of that. And then similarly, the proposed U11 playfield, which is at the far south end of the site, is no longer present. And nope, that's not it, sir. Immediately south of the orange building. That's where the original U11 ball field was supposed to be installed. And now it's a parking lot. And furthermore, the parking lot is larger in design than what was originally presented to the community, which kind of runs counter to the idea of a shared parking arrangement with Cadell Rec Center, which is the building to the northwest here. So this is the conceptual plan. This is the final approval from February 9th, 2023. And this is the approval that I'm looking to have the BZA reverse today. Coming through here, these are the minutes of the BZA meeting. And I included this just so that you would have the opportunity to review what was spoken during that meeting. It starts on page 5. Again, this was case 22-064. And ultimately, the BZA, the Landmarks Commission passed this motion through. So my contention here is that the Landmarks Commission did not review this project within the context of the legally binding codified ordinance that City Council passed governing the development of this site. Originally, they had said they were going to have a shared parking agreement and the replacement of a U11 ball field on the site of the building that was going to be demolished. And ultimately what Landmarks passed was not that condition. They passed a building that extended further up to Detroit Avenue. There was no replacement of the U11 ball field, and the parking is larger and doesn't support the idea of a shared parking arrangement with Cadell Rec. So that's item 1. If you will, of my appeal that I'm offering here today.
Madam Chair, for the record, everything that was just read, that's all part of one exhibit. You mentioned several exhibits, but I only heard Exhibit A. So is that packet that you're referring to all under Exhibit A?
No, ma'am. I'm sorry. What we just went through here, I apologize, is we went through exhibits A through F1.
Okay. Madam Chair, we're going to need something with the exhibits labeled, because I don't seem to have. Is this
Pat passed it to you.
was this in there? Is that what you're saying?
That was his, in this packet.
Yeah. That's the lead out page of the packet that I sent was it has the list of the exhibits on it.
It's after your letter. There it is. Thank you.
It's just 2 pages.
Got it. Thanks.
And as I mentioned for the first part of my appeal, I referenced exhibits A through F1. Secondly, I assert that the Landmarks Commission acted arbitrarily by not properly receiving, reviewing, or approving the final environmental changes as required by Cleveland Codified Ordinance, Chapter 161.05. That's Exhibit A, or excuse me, it's Exhibit J in your packets, which is a bit further down. A brief timeline of the events associated with the required receipt and review of the tree preservation plan is that the Landmarks Commission first heard case number 22-064 on August 25th, 2022 for conceptual review, and then subsequently approved a certificate of appropriateness on February 9th, 2023 during final review. The plans that were received required the removal of 30 or more trees, grading activities, building activities within a designated landmark district, and environmental change, to be sure, when we're talking about removal of trees and earth disturbance. While Landmarks Commission Secretary Dan Musson indicates that the tree protection plan was received by Landmarks as part of the final package, which is Exhibit I. Exhibit I is an email from Secretary Musson to Councilwoman Jenny Spencer and myself.
Oh, is it in person?
He goes on to state regarding the tree protection plan that when we require a tree protection plan be submitted with final plans, we do not await approval from Urban Forester before the commission approves the project.
Excuse me one second. Folks online, we're picking up audio from you. And we're gonna need you to mute yourself, please. Thank you. All right, I apologize for that. Please
No problem.
proceed.
Yes, I'll reread that. In an email from Secretary Musson to Councilwoman Jenny Spencer, he says that when we require a tree protection plan be submitted with final plans, we, which is Landmarks, do not wait for approval from the Urban Forester before the commission approves the project. Mr. Musson's statement is troublesome, given that the initial tree protection plan was not submitted to Jennifer Kipp of Urban Forestry for review until 4/26/2023, an action that Mr. Jeff Henderson, who is CMSD's architect, categorized as a misstep. Furthermore, a revised tree protection plan was prepared as recently as August 22nd, 2023. The process described here essentially depicts that Landmarks Commission granted a certificate of appropriateness without knowing the full extent or reviewing the final environmental changes associated with the project as required by them under Cleveland Codified Ordinance, Chapter 161.5. And I'm going to click through here. Let's see if this is going to wake up. It looks like it fell asleep, maybe. There we go. Maybe. Is this me or you doing it?
That's you.
Okay.
Yeah.
Right. So this is the email that I referenced from Secretary Musson to Councilwoman Spencer and myself. And in there you can see, which is the, excuse me, these tabs are sticking together a little bit. You can see the first bullet point on the second page here says, I'm unsure if the tree preservation has been approved by the Urban Forester. When we require a tree preservation plan be submitted with final plans, we do not wait for approval from the Urban Forester before the commission approves a project. And here is item J, Exhibit J, which is the ordinance relating to the evaluation of environmental changes associated with historical district. It says, I'll read the highlighted portions. No person shall make any environmental change unless a certificate of appropriateness has previously been issued by the commission with respect to such environmental change. And for any environmental change on one or more acres of land, a copy of a tree protection plan meeting the requirements set forth in section 341.051 within 7 days after the receipt of the application. Chapter 341.051 is the Urban Forestry Code.
Can you just reread that segment that you just read?
Yes, ma'am. No person shall make any environmental change unless a certificate of appropriateness has been previously issued by the commission with respect to such environmental change. And then it goes on to say, and for any environmental change on one or more acres of land, a copy of a tree preservation plan meeting the requirements set forth in section 341.051 within 7 days after the receipt of the application. I'm unaware of when Landmarks Commission received the required tree protection plan that would have gone into their planning process. I am aware, though, that a certificate of appropriateness was issued on February 9th, 2023, and a revised tree protection plan was provided by CMSD and their consultant on August 22nd, 2023. So again, the environmental changes were not finalized prior to the Landmarks Commission issuing their certificate of appropriateness.
What's the disposition of those trees at this point?
The trees are still standing, ma'am.
Okay.
I contend that the estate gift of Frank Cadell's land to be preserved as a park forever i.e. open space and trees, and that the building of a clock tower on that site in his memory serve as the foundation of the historic nature of Cadell Commons Park, which is chapter 161.05. It describes a process whereby the Landmarks Commission and the applicant could have, I contend they should have, agreed to a delay to, this is quoting the ordinance, conduct further investigation with regard to the proposed environmental change, conduct negotiations with the applicant and any other party in an effort to find a means of preserving the property, or explore alternatives to the proposed environmental changes. Again, I'll reference Exhibit J, which I've have on the screen and have read through. The environmental aspect of the historic nature of the Cadell Commons Park within a designated historic district was never contemplated by the Landmarks Commission. The Commission's decision to ignore that environmental change was an arbitrary application of their authority. On August 21st, 2021, Dr. Roy Larrick, get back to this exhibit here with Dr. Larrick. Here we go. Dr. Roy Larrick of the Early Settlers Association of the Western Reserve published a very thorough, albeit he called it a self-identified first attempt study, that's Exhibit G, which is on the board right now, of the Cadell Commons Park and potential development alternatives. His study's attached, and within his study, I'm going to quote a large section of Dr. Larrick's study for the board here. A holistic conservation plan should be based upon the very high value of the clock tower and the generally high value of nearby trees 10, 11, 12, and 13. Those are specific trees that were called out in the tree protection plan, some of which are intended to remain, some of which are intended to be removed as part of the tree protection plan.
Are they specified by species?
They are. It's a separate exhibit, ma'am,
Okay,
which is right here. Here's a whole listing of all the trees in the
All right.
park with different attributes and codes associated with them.
okay. It lists their species and their age? Or-
It lists their species, ma'am. Age is a more intensive process to determine
Right.
what those are.
Okay,
The plan would, the plan would revise the proposed school footprint to stay mostly south of the athletic field's northern border. Any northward projection would cover the abandoned West 99th West Boulevard alignment. This revision would keep the clock tower unencumbered and save the high-value trees as a legacy group. This assemblage could be the anchor for a new canopy development during the next several decades. I should click through to where it actually says this. A last stand conservation plan would have the proposed school footprint retreat south enough to save tree number 10 as a pair with tree number 11, which is not scheduled for removal. He says that, I don't see how this plan could be refused. It's important to try for the full plan while recognizing that a lesser plan may be the reality. Still, saving number 10 would be a significant accomplishment. I highlight Dr. Larrick's study, which again, he self-identified as a first attempt study, to show that Landmarks Commission was arbitrary in their application of evaluating the environmental changes. The record will show when you look through the transcripts of the February 9th, 2023 meeting that some mention was made to sensitive areas, but the Landmarks Commission board members did not really go into any great depth of discussing the trees or the historic nature of the trees within that historic park. More so, there was a lot of focus paid to the building finishes, such as the brick, the metalwork, the colors, and things like that. Had Cleveland Landmarks Commission exercised their authority under Chapter 161.05, I think that they would have been able to come to an understanding that there were other alternatives and that a negotiation process between the applicant, which is CMSD, and the city of Cleveland and the Landmarks Commission could have been achieved. If Dr. Larrick was able to put this together over the course of a week or a weekend, I think a commission board of the city could have done as sufficient of a job with this.
what was the extent of public meetings on this? I mean, what did the tree and the whole nature of the historic district come up for discussion in a public meeting?
The trees have always come up as a topic of conversation within the public meetings. Again, the record of public meetings from CMSD to the community has been mixed. The the initial, I guess, application or development of this site began to occur in 2019. CMSD would contend that it occurred earlier than that in 2014, but in 2019 is when CMSD reaffirmed their master plan. We call it a change to their master plan. Previously, CMSD had talked about the children in the existing Marion Seltzer School being able to be moved or swung to a different school site, and then the building demolished and rebuilt on its existing site, which is something that CMSD has done with a number of other buildings as well. After 2019, the Board of Education identified that they needed more parkland in order to facilitate the building of a new Marion Seltzer School. And the parkland the land that was identified was the parkland, Cadell Commons Park, which was immediately adjacent to that. In March of 2020, COVID happened, and the CMSD kind of went into a hiatus on planning. What didn't happen, though, was that the Commissioner of Real Estate and City Council didn't go into a hiatus on transferring the land. And so when you look at Ordinance 75-2021, you'll see that that was approved in March of 2021 with no special public notice aside from what would be considered normal committee meetings and normal council meetings, which were all virtual at the time. The lot splits and the conveyance of the land from City of Cleveland to CMSD occurred in July of 2021. And then after July of 2021, we come around to the first public meeting that CMSD held with any specificity of the school, which was March of 2022. And those were the plans that I showed you that had the building as a compact design south of the clock tower. It incorporated the existing U11 field, which was required as part of that the land swap legislation. And it also seems to have contemplated, because it had a reduced size parking lot, seems to be conforming to the idea of a shared parking arrangement, which was also part of the land swap ordinance 75-2021.
And
I'm sorry,
just
go
one
ahead.
second. You're going faster than I am taking notes here. So when again was the date of the lot splits and the conveyance of the land?
July of 2021.
Okay, great. Okay, go ahead.
Sure. And during that March of 2022 meeting, just to round out the idea of what the community engagement process was, during that meeting, there was a community survey that was put out to the community saying, we'd like you to make some binary choices. Do you like brick, or do you like metal and glass? Do you like neutral tones, or do you like kind of red brick tones? Do you like playful elements, or do you like more conservative elements? So there were these about 13 binary choices given to the community, which, taken in the context of what was presented, a building, and then given some choices about, how do you want to pick out the carpet and drapes with these binary choices of brick versus glass, it led the community to believe that the plan, which was presented in March of 2022, was pretty close to the final design. During that meeting, CMSD also said that they were going to come back to the community in about 45 days or May of 2022 with the results of that survey and kind of present to everybody what the presumably final design might look like based off of the results of that survey. That May of 2022 meeting never happened. The next time that CMSD came to the community was in October of 2022, which was already two plus months after CMSD had started the permit application process of going through local design review, of going through landmarks. So CMSD never came back to the community with that changed design, that elongated building. They came back to the Landmarks Commission and the city's review process. And so
Without public input.
well, that would be my contention, Madam Chairman. I think some people might say that community input was available to people if they attended the public meetings of Landmarks and
Okay.
Design Review Board.
Sure, right.
However, I can tell you that not many people are tracking when landmarks and design review meetings are, nor do they attend those things kind of virtually or in person. So I would contend that short of getting a public announcement to say, come out to the school and see our final designs, most people are probably not engaged enough to understand what the design changes were. So again, that brings us up to October of 2022. CMSD is already into the permitting process, if you will, with landmarks and building and housing. And then they finally come to the community. And from October of 2022 until really July of 2023, there was kind of a slow simmering burning of, public outcry that continued to get more and more intense. People contacting, their council people, neighbors talking to each other, trying to figure out what was going on with the school, which ultimately led to a July 11th, 2023 meeting, which Councilwoman Spencer hosted at Cadell Rec, where the community had an opportunity to finally ask CMSD, what happened with these plans? What's going on here? During that July 11th, 2023 meeting, CMSD took down a lot of notes. They said they would go look for alternatives and so forth. And they came back to the community about a month later on August 9th, 2023. So we're getting pretty close to present day time now.
Yeah.
And when they came back on August 9th, 2023, they essentially said, we explored some alternatives, but none of them work. Wish you had been here 10 years ago when we started the planning process, which has resulted in some community outcry, which has resulted in me coming before the board today to seek whatever remedies that are available. I do have one more section. So I've been through item number 1 and item number 2, which related to the environmental changes. And then item number 3, this one's shorter, and I do appreciate the board's time and listening to me here. Thirdly, I assert that the Landmarks Commission acted arbitrarily when the commission failed to protect a landmark parcel within a landmark district in violation of their defined public purpose, which is Cleveland Codified Ordinance, Chapter 161.01A. And let me flip through here so we can look at that ordinance together. That's Exhibit K, for those of you who are tracking along here. And the defined public purpose says, Council hereby declares as a matter of public policy that the preservation, protection, perpetuation, and use of areas, places, buildings, structures, works of art, and other objects having a special historical, community, or aesthetic interest or value to the public necessity and is required in the interest of the health, prosperity, safety, and welfare of the people. The purpose of this chapter is to, item number A, safeguard the heritage of the city by preserving sites and structures which reflect elements of the city's cultural, social, economic, political, and architectural history. Landmarks Commission Secretary Dan Musson stated in his email, which we're going back to Exhibit I here. Thanks for being on the flip chart with me. That the land swap of the historic parcel in the historic district was, and I quote his email, was handled before Landmarks' involvement. By not conducting a thorough review of the circumstances which led to the land swap of a historic parcel and the subsequent development of that parcel, they failed to fulfill their public purpose of, quote, safeguarding the heritage of the city. In this circumstance, we can all try to understand what happens between different divisions and departments of the city. But if you'll recall, the legislation governing this land swap occurred in March of 2021. And then the actual devices which split the land and conveyed the property to CMSD happened in July of 2021. And Landmarks presumably did not hear this case until its first conceptual review in August of 2022. So in that regard, I think there was a breakdown between the Mayor's Office of Capital Projects and the Department of Real Estate, not consulting with the Landmarks Commission when they were contemplating the swapping of this land, the devices which would convey the land, and then ultimately the redevelopment of the land. So the Division of Real Estate sort of did this in their own silo. And as Secretary Musson said, it was not until the project came to Landmarks that he was aware of the project. So in conclusion, I believe that the Board of Zoning Appeals should, I wrote nullify here, but I think the actual term would be reverse, should reverse the certificate of appropriateness issued by the Landmarks Commission and require the applicant, which would be CMSD, to return to the review process. That's all that I have right now, Madam Chair.
Great, thank you. Thank you. You may have mentioned this, but who are you actually representing?
I'm representing me, ma'am.
Just you,
Yes, ma'am.
as a resident?
As a resident, yes, ma'am.
Okay. So there is no resident or organization around this?
There is a group called the Friends of Cadell Commons Park, and we're currently involved in a separate action, which is not related to review of the landmark certificate of appropriateness.
Okay, great. Just wanted to make sure.
Yes, ma'am.
All right. Okay. Are you ready?
I think so.
All right. We'll proceed with you.
Slide deck coming up here.
Dan, you can use the record.
Cool, thank you. Yeah, Dan Musson, Secretary of the Cleveland Landmarks Commission.
Thank you.
Looking at the 1468 West 98th Street, again, this was Landmarks case 22-064.
1 second, Dan. I just want to make sure everybody, my board members online, are you hearing his audio okay? Okay, great. All right, go ahead.
Yeah, as Mr. Eisenbach said, this is not only in the Clifton West Boulevard Historic District, which is a Cleveland Landmark District. It's also involves a individually designated landmark, which is the Cadell Clock Tower. So just a brief timeline. I know we just went through all this, but I guess recap. On August 10th, 2022, the concept was brought before the Clifton West Boulevard Design Review Committee and feedback was provided. And then on August 25th, 2022, the concept was reviewed by the Cleveland Landmarks Commission with feedback provided by the commission. January 18th, 2023, final review of the project was undertaken by the Historic West Cleveland Design Review Committee. There's a name change in there of the Design Review Committees. Mm-hmm. Historic West Cleveland kind of was a merger of the Clifton West Boulevard, Gordon Square, Franklin West Clinton, a few different
right.
Historic districts are seen by this committee now. And finally, well, on February 9th, 2023, there was a final review conducted by the Cleveland Landmarks Commission. And then the certificate of appropriateness was actually issued on May 1st, 2023. At the August 10th, 2022 meeting, the Design Review Committee provided conceptual feedback, which was then provided to the Cleveland Landmarks Commission. So routinely, when a project comes for concept, there's no vote taken, and any feedback from the committee is shared with the Landmarks Commission when they review it in concept, which happened on August 25th, 2022. Again, there was no vote taken. Committee heard, or the commission reviewed the project, provided feedback, took into consideration the comments from the Design Review Committee. Then on January 18th, 2023, the Historic West Cleveland Design Review Committee reviewed the project for final approval. They voted to recommend approval to the Landmarks Commission and requested that the applicant return for landscaping changes on the joint city-school common space. That was by a vote of 5-2. And at the time, Mr. Eisenbach was a member of the committee, and I believe voted to approve at that time.
It's unfortunate, but yes.
Okay.
Then it came to the Cleveland Landmarks Commission for final review on February 9th, 2023. The commission voted unanimously to approve the project with consideration to review the color and/or extent of the metal panels and return to staff with a final solution. The tree preservation plan was included in this presentation. And then finally, on May 1st, 2023, the certificate of appropriateness was issued. And I issued this after the conditions of the Landmarks Commission approval were met. So we worked with the architect and CMSD to finalize the details that were kind of outstanding or of concern to the commission. So just to walk through Mr. Eisenbach's arguments real quick. It says, firstly, I assert the Landmarks Commission issued a certificate of appropriateness illegally approving a site plan which contradicts the approved legislation governing the development of the site. I just would go back to chapter 161.05C, which says the commission finds that an environmental change proposed by the applicant will not adversely affect any significant historical or aesthetic feature of the property and is appropriate and consistent with the spirit and purposes of this chapter, then the commission shall issue a certificate of appropriateness. So our charge is to review things using the Secretary of the Interior standards for rehabilitation. And if we find that it's appropriate, we're bound to issue a certificate of appropriateness. If we find that it's not appropriate, the commission denies it and there's no certificate of appropriateness issued. So we routinely approve plans that might not necessarily meet all city code. I mean, that's why cases come before you guys for, in the Board of Zoning Appeals when there's, different issues as far as setbacks and that sort of thing. We're just looking at appropriateness in a historic district or of a historic property and making sure that it meets those 10 points of the Secretary of the Interior standards. The appellant secondly asserts that the Landmarks Commission acted arbitrarily by not properly receiving, reviewing, and approving the final environmental changes as required by Cleveland Codified Ordinance, Chapter 161.05. And for a point of clarification, environmental change as defined by Chapter 161.02E means any alteration, demolition, removal, or construction of any property subject to the provisions of this chapter. It's not referring to ecological or that type of environmental change. It's change when you're historic preservation. When you're talking about environmental change, you're talking about building something, tearing something down, altering the site in some way, not specific to, I guess, the environment So the Landmarks Commission followed the policies and procedures outlined in Chapter 161 and in the rules of the Cleveland Landmarks Commission in its review of this proposed environmental change. It went to, local for concept, then to the commission for concept, back to local for final, then to the commission for final. We resolved any outstanding issues, and then the certificate was issued. That's our process. The appellant thirdly asserts that the Landmarks Commission acted arbitrarily when the commission failed to protect a landmark parcel within a landmark district in violation of their defined public purpose. He says, by not conducting a thorough review of the circumstances which led to a land swap of a historic parcel and the subsequent development of that parcel, they failed to fulfill their public purpose and, quote, safeguard the heritage of the city. So as defined in Chapter 161.05, the Landmarks Commission regulates environmental changes through the issuance of certificates of appropriateness. If there's no environmental change being proposed, meaning, a transfer of property or change in property ownership, refinancing, that sort of thing, the commission does not have authority to intervene. We're only looking at proposed changes, physical changes, environmental changes to a property, and reviewing those for appropriateness with the Secretary of the Interior standards.
Essentially, any site alteration.
Correct, yes. And the transfer of property or land swaps are not under our purview. So in conclusion, the Cleveland Landmarks Commission was neither arbitrary nor capricious in its review of the issuance of Certificate of Appropriateness 22-064 for the Marion Seltzer School. That's all I have.
Okay. With regard to the meetings that you were present for in this process, were there, do you recall, or do you have any notes or documentation of the public participation, feedback, any comments that were made at those meetings?
As far as the local committee meetings go, I don't believe there was any public comment provided to the commission. I don't believe we had any in the actual commission. I guess to be clear, I was only present in person for the February 9th, 2023 Landmarks Commission meeting. Having just started in this role at the end of December.
Right.
I'm like halfway through the process.
Right.
But yeah, I don't believe we received any public comment outside of the comments from the design review committee. and the feedback that they provided. And they're typically members of the community, a lot of times with design backgrounds, sometimes community members just try and vary the backgrounds to get the, I guess, the most diverse opinions.
Right, okay. Liz, do we have any correspondence?
Other, just what Mr. Eisenbach submitted.
Okay,
Nothing
so
from-
nothing from council, nothing from the public.
No.
Okay, all right.
I mean, I'm sure I did have a question to the landmarks secretary. Is there anything in the codified ordinances that requires, any public notification or, any additional public meetings? Like, what is the responsibility of landmarks to have to hold public hearings?
As in similar to ours,
Yeah. right.
giving
Is there
public
any-
notice
Yeah,
in
so
advance?
So we have public meetings. We occasionally hold a public hearing, which is, that's when we're looking at landmarking a property. Typically, we have a public hearing, but otherwise they're public meetings. They're posted to our website, the agendas and project information. We don't do any kind of specific outreach like you guys do, with
Mhm.
mailing letters or posting signs. That's not anything that's in our ordinance or has ever been required in our rules. So it's just the typical public meeting notice on the city's website. And we do have, our meetings are regularly scheduled. So they're
Right.
the second and fourth Thursday of every month. So
Okay. That answers the question
Yeah, I
there.
just wanted
So,
to clarify from my notes. Thank you.
yeah, different requirements than what we have in our rules. Okay. All right. I will open it up to questions or comments from the board.
Well, I do have a few,
Fire away.
as you expected.
Yes, thank you for that.
I want to ask some questions about the protection of trees, the plans, and some of the comments that have been referenced. The study conducted by Dr. Lyric was done for whom and presented to whom and when?
Yes, ma'am. Through the chair, Ms. Brown, the Dr. Lyric study was conducted by Dr. Lyric, of course. He became aware of the removal of trees on the site, and in his own professional life, he's involved with the study of trees in the Bluestone watershed, which is kind of the east side Euclid Heights sort of area, in addition to his work with the Moses Cleveland trees through the Early Settlers Association. So Dr. Lyric is a tree advocate, and when he found out that the trees were going on, that they may have been threatened at Cadell Commons Park, he went out and conducted this study for his own
On his
advocacy.
own.
On his own, yes, ma'am.
Got it.
He had subsequently then provided it to the Friends of Cadell Commons group as we were building a social media campaign and trying to raise awareness about what was happening at the park.
Was that also shared with CMSD and with the city of Cleveland?
Yes, ma'am.
And then to you, Mr. Munson, when you talked about the responsibilities of the commission and alterations, it's related to the built environment. Who at the city, if not landmarks, would be responsible for considering any adverse effect on the tree canopy? This reference that, sorry, your name, Mr.
Eisenbach, ma'am.
Eisenbach references as the tree protection plan.
Thank you, Ms. Brown. So in our ordinance, it does, as Mr. Eisenbach quoted, require that a copy of a tree preservation plan be submitted before a permit is issued. So, trees and the impact on, on the site, landscaping, that sort of thing, is something that the commission considers. Ultimately, the folks over at Urban Forestry are responsible for reviewing and approving the tree preservation plans. So, my understanding of that process is that, they sort of evaluate each tree, place a value on it. If a tree is coming down for a project, they'll say, okay, you need to, plant additional trees here, or I think there's a fund you can pay into to add trees in other areas. But it's, the Landmarks Commission does, and in every meeting through concept level and the final reviews, the trees were brought up, they were a point of discussion. The first concept meeting, I think, there was like 45 minutes of discussion at each of these meetings. And it certainly included concerns about the trees that were raised. And as I said, ultimately, the local design review committee voted 5-2 to approve the plan, and the Landmarks Commission voted unanimously to approve the plan.
I got that. I'm still asking you at the city.
Mhm.
Did Urban Forestry actually review and approve it, or do you know?
My understanding is it was submitted to them, and then with some revisions were made. I think you said in August it was resubmitted. So I don't know if there's been a final approval, but the resubmission of a plan to me means there's been some back and forth, and
Sure.
they're working out the final details.
Thank you.
So at this point, you have nothing from Urban Forestry.
No, and our ordinance doesn't require an approval from Urban Forestry. It just requires that a copy of that plan be submitted to us. So,
Okay.
There's,
All right.
Thank you.
Anything else? Ms. Wilson?
You probably don't know, but I'd be curious to know if we can anticipate when the department finalizes their opinions about
on Urban Forestry. I'm not sure. I don't know if Mr. Eisenbach, have you heard anything about that process or where they are in it?
It's my understanding that the urban forester was told by her supervisors that she would approve the tree preservation plan that was revised on August 22nd. There was some discussion between Councilwoman Spencer and Jennifer Kipp, who is the urban forester, about maybe holding that approval until some of this community engagement, the community outcry was settled or determined upon. And our group had initially scheduled a meeting with Chief Pomerantz and Chief Davey to try and talk through some of these things. And it was during that discussion, when we were coordinating a meeting time, that it became known to us that Jennifer Kipp's supervisors told her she will sign the tree protection plan to continue the process moving.
The final iteration of that.
It's my understanding it was the final iteration, ma'am.
Okay. Anything further, Ms. Wilson? Ms. Roca?
I have one more question.
Go ahead.
Have the building permits been issued?
I don't know.
It's my understanding no permits have been issued for this yet. So
I do know that the plans for the elongated building and so forth have been submitted to Building and Housing, are in the review process.
Okay.
Madam Chair,
Yes.
could we have our attorney read the legal standard again so that we could also just remind board members what we're here for? It's
Right.
not a variance standard that we're looking at.
Exactly.
Different.
Madam Chair, members of the board, Helen is appealing the decision for the Landmarks Commission to issue a certificate of appropriateness. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by preponderance of substantial, reliable, and probative evidence. If appellant fails to meet the burden, the administrative decision must be affirmed.
Thank you. 1 second. Ms. Roca, any questions or comments?
No, Madam Chair, Ms. Brown's question about the tree plan and, the testimony that the ordinance does not require approval by Landmarks for the tree plan answered my question.
Okay, great. Ms. Holzer, anything?
I'm following, thank you.
All right, back to you, sir.
Yes, ma'am. If you will, I don't want to play tit for tat, but I do want to make sure that all the board members are aware of a close reading of the ordinance. Secretary Musson testified that an environmental change speaks to buildings and any sort of change to that environment that would occur on the site. When we look at chapter 161.05, and I don't know if you want to flip back to my exhibit so I can pull this up. Hold on.
Okay, go ahead, you two.
Good, we are right there at the top. He asserted that the environmental changes relates to the buildings and other sorts of aspects like that. And it does reference this. When we look at paragraph A here, which is the second paragraph, any applicant to the Department of Building and Housing for a building permit for an environmental change shall also be deemed an applicant for a certificate of appropriateness and shall forward to the commission together with copies of all detailed plans, designs, elevations, specifications, and documents relating thereto. To me, I read that as the building plans, the designs of the site. But then it goes on to say, and for any environmental change on 1 acre or more of land, it also says any environmental change to an apartment, townhome, condominium, or 4 more units of any size parcel, a tree preservation plan meeting the requirements set forth in 341.051 within 7 days of the receipt of the application. So I would like to counter the idea that an environmental change as contemplated by this ordinance simply refers to the buildings and the design of the buildings, because there is an entire separate call out here, which is highlighted, that talks about trees specifically.
Okay, great.
Thank you, ma'am.
Thank you. All right. If there are no further questions or comments, I will entertain a motion. Ms. Roca, Ms. Wilson?
I apologize, Madam Chair. I'm spending some time with this ordinance, so if you could just give me a minute.
Absolutely.
All right. Upon hearing the testimony from the Landmarks Commission as well as the appellant, I move that we affirm calendar number 23-165 and and hold to the decision of the Cleveland Landmarks Commission in this case.
Could I have a second, please?
Madam Chair, I would second.
All right, Ms. Wilson for the second. Would you like to call the vote, Ms. Kukla?
Sure. Ms. Brown?
Yes.
Ms. Holzer?
No.
Ms. Wilson?
Yes.
Ms. Roca?
Yes.
Ms. Bates?
Yes.
Calendar number 23-165 is denied. The decision of Landmarks Commission is upheld. This decision will be ratified next Monday. We will send the appellant a letter. Thank you.
Thank you very much.
Thank you.
Thank you
Thank
both for
you
your
both.
testimony.
Thank you. For your first time at BZA, you did an excellent job.
Wonderful. Thanks for letting me get this information to
Yes.
the public.
Absolutely.
Madam Chair, we do have another case here for Landmarks. I'm not sure if the secretary is going to stay for this. It's calendar number 23-138 at 3820 West 33rd Street. Cheryl Manthey proposing to install 120 linear feet of 6-foot tall fence.
Were you planning on spending the morning with us?
Yes, yeah, clear my calendar. So
Okay.
Mr. Brown is here with us as well.
All right, great. All right, so since we have the landmark secretary with us, Ms. Holzer, we're going to move on to calendar number
Sorry,
20.
guys. Sorry. sorry. I'm just apologizing to the folks that just stood up.
Oh, okay. Sorry, gentlemen. We're gonna move on to calendar number 23-138.
Sure thing. Our next case is calendar number 23-138. This is at 3820 West 33rd Street. Cheryl Manthe, owner, proposes to install approximately 120 linear feet of 6-foot-high wooden fence in a C1 multifamily district, residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 3. This case was postponed from May 8th in order to allow time for the appellant to consider updating plans to be more code conforming. It was again postponed on July 10th to allow time for 4 BZA members to be present. And finally, it was postponed from August 7th to allow time for 5 board members to be present. And with that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Holzer.
Mhm.
Go ahead and swear everyone in who is going to speak on this matter. I will state your oath. Please reply with "I do," your name and your address. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth?
I do. Carl Bender, 601 Lakeside.
I do, Dan Musson, 601 Lakeside Avenue.
Is there anyone online wishing to speak in this matter?
I do. Cheryl Manthe, 3820 West 33rd Street.
Thank you. Is there anyone else online? Okay, back to you, Madam Chair.
Thank you. Could we have, since we're gonna reread the history since it's been several months since we've heard this case previously.
Yeah, Madam Chair, actually, I think the most important information will be notes from the last hearing.
Right.
Just as for the record, we've already given the zoning and permit history on this project. I would state that there was a violation issued because the fence was constructed not in accordance to the permit that was issued. And I would state that the applicants at the May 8th hearing expressed concerns about safety. They found drug paraphernalia in their yards. They want to secure their perimeter. They believe that a criminal can jump over a 4-foot tall fence. Mr. Brunges from Landmarks Commission stated that there was a complaint sent to the inspector that there was work being done without a permit. And that's when the information regarding what was the details in the permit, and those details are that a 4-foot tall fence would be constructed that would be 50% open. Apparently the applicants applied to building and housing and were denied, and that's why we're here today. There's a notice of non-conformance that was created. The board understood the security issues. Ms. Brown asked the appellants to work with the staff on the design. Chairwoman stated, quote, "The 6-foot solid fence cannot remain. The board cannot approve it, and it needs, as it is, it needs to be modified." And the board asked that the appellant bring a copy of the contract with the fence company and proof or new design showing that they've consulted with the city, specifically the Landmarks Commission. Thank you.
Thank you. All right, let's review the legal standard again on this.
Madam Chair, members of the board, appellant is requesting an area variances from the fencing requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting variances will not be contrary to the purpose and intent of the zoning code. And as a note, this application requires approval from the Landmarks Commission. And on March 9th, 2023, the Landmarks Commission denied the application, and denial has not been appealed.
Thank you. All right. So to the appellant, Cheryl, when we initially met with you, Ms. Kukla just read a summary of the testimony that was given that day. And I believe that we had asked you to work with the city planner for that area, as well as trying to come up with a plan that was more code compliant. So can you bring us up to speed on what you've done since we saw you in person last?
I've been, well, mostly I've been trying to figure out what would be an appropriate change that would not cause the unnecessary hardship of the safety concerns that I testified to in the previous hearings. So I have not submitted a change, a new type of plan. I can't, for the life of me, come up with an alternative plan that I think would be safe. So I'm stuck. I guess you could say I'm stuck. No one submitted any plans or alternative proposal plans to me, so I don't think any city planners have done anything either, so.
So did you reach out to city planning to meet with a planner for your area?
I thought it would be the Landmark Commission. Yeah.
Okay.
It's hard to know sometimes who all to talk to. Landmark is a zoning appeals and all contractors, Landmark.
Yeah.
Commission.
Yeah.
So the Landmark, see, I don't know. I thought is the city planner the same thing as the Landmark Commission, or is that a fourth party?
No, they're within the city planning department, there are city planners for every neighborhood within the city. And it was my recollection at this point that we actually put you in contact or gave you the contact information for the planner, or at least instructed you to call city planning. So it sounds like that didn't happen.
So okay, because I thought we had to, come up with the plan and then submit it to somebody.
No, they would have worked with you.
Okay.
All right.
So city planning.
Yeah.
Okay.
So, all right, we're gonna move on, and we're gonna hear from. Do you want to go first?
Sure, thank you. Carl Bruntis, Landmark staff. I just want to make one slight correction to the record. There was a complaint for a fence installation without a permit on January 14th, 2021, and that's where the violation notice was generated from. So we're going on a while. Everything else I'm good with. Just also, yes, there are city planners, but when it's a landmark building or within a landmark district, Landmarks has the jurisdiction, so we would come to us.
Okay, great.
So it's not the city planning, okay.
We are in the, ma'am, we are in the planning department, but because it's a landmark district, we have the jurisdiction.
Gotcha.
We listened to make sure that Ms. Kukla had updated everything and that they were instructed to get the original contract together and submit that with the new design. The appellants to date have not reached out at all, nor gotten any information to us. And the onus is on the appellants to get us that information. And we stand by our original request. We note that a 6-foot fence of any nature is inappropriate in the front yard of a resident. So we would reiterate our request for the denial of any variance for this project.
And it's actually more unsafe than ever at my house. I was on my front porch several nights and people live in
Ma'am, you can't just make comment like that, okay? We will call on you and it has to come through the chair whenever you make a comment. And we did hear your testimony about your claim to it being unsafe when we heard the case originally. All right, do you have anything to answer?
Nothing else to add.
Okay. City planning, anything else?
No, Madam Chair, we of course support whatever the Landmarks Commission has to appropriate for this site. We also do not feel this 6-foot-high run board wall on the entire front of this property is appropriate. It would create a walled neighborhood if everybody else on the street decided they needed to have a 6-foot-high fence because they, have the same security issues, perceived security issues. I would also like to state or remind the commission board, of you know, the security problem and the hazard that this fence creates. And we have Rose from the neighborhood has submitted a letter, and it's kind of, you can see it here, where if you're pulling out of the driveway, and there's two driveways, one on either side of this, if there happens to be a little child or something walking along the street next to this 6-foot wall, the person would not be able to see the child walking. And so they've had several close calls with children on bikes and children walking. And so that's a real problem. And here you can see on the bottom right photograph, we have another neighbor who is up against the 6-foot wall that's been installed without a permit. And there's a car there. Now you can see that car, when they pull out, if there's a child or a person on a bicycle or walking, they're not going to be able to see them because of this wall that completely blocks the view of the sidewalk. So this is really creating a safety hazard for the neighborhood. And it just doesn't send the right signal either for what we want in our neighborhoods, to create walls in communities. And so we support what the Landmarks Commission has decided here. And we also do not condone things being erected without the benefit of a permit, or ignoring a permit that was issued and doing exactly opposite of what was actually approved.
Thank you, Mr. Rillens. Board, any questions or comments?
I'm sure I was not here for when this was first done. I want to make sure I understand the applicant's position. Is it that the fence is necessary because of security reasons?
Correct.
Okay, I want to make sure I understood that. Thank you.
Madam Chair, Mr. Riccardi, I believe, is on the line. Perhaps the board would like to hear exactly where a fence is permitted by code.
Correct.
I know myself that solid fences are not permitted in the front yard. They need to be set back behind the front porch. I believe it has to start in line with the facade of the building. So just so the code knows, so the board knows that it needs to be 50% open in that front yard, as well as being ornamental. It can't be chain link, and it needs to be 4 feet tall. I don't know if I'm missing anything, Mr. Riccardi. I believe that he's
2.5 feet at the intersection of the driveway.
Right.
And 75%
So that
over
is-
2.5 feet.
So the other issue, Madam Chair, and I think it might be also in the write-up, is that where the sidewalks meet the driveway and the fences meet each other, it does create that dangerous situation. The code requires that from that point, the fence needs to be set back 15 feet in each direction. And so ideally, it would be that would give the view for the person pulling out. But the code also does not allow a 6-foot tall fence in the front yard or even in the side yard without a variance. It has to be open, 50% open and 4 feet tall by code.
Okay, board, everyone clear on that? Does Mr. Riccardi want to make any further statement?
Richard Riccardi, zoning administrator. That was a good summary of what fence is allowed, the legal way to place the fence, and with the permit. I mean, this is just a case of an illegal fence that appears to be very, very hazardous, put up without or contrary to a permit, and with absolutely no grounds being presented to the board in regards to the standard for granting a variance. Thank you.
Thank you, Mr. Riccardi. To the appellant, we first heard your case May 8th. I was sensitive to your comments about your concerns about your personal safety. We've had, since then, you've had the opportunity to postpone because we were short board members. And so because of that, and our option to let you postpone, you were able to do that from May until October. I have to honestly say that I'm very disappointed that in the months since May 8th, you did not take the opportunity to meet with anyone from the city or provide any alterations to the fence to make it more code compliant. You are now, as you have heard, in a situation where you are causing a safety risk to your neighbors and those people that are using the sidewalks and your adjacent neighbors in the driveway. So it is unfortunate that in the months since May 8th, you are not able to make necessary changes or meet with anyone so that you could come into compliance. So with that, board, I will entertain a motion.
Madam Chair, I would, based on the testimony that we heard today for calendar number 23-138, I would move to deny this application.
I will take a second, please.
Board Member Roca seconds.
Thank you. Ms. Kukla?
All right, Ms. Holzer,
Yes.
Ms. Brown,
Yes.
Ms. Roca,
Yes.
Ms. Wilson,
Yes.
Ms. Biggs.
Yes.
Calendar number 23-138 is denied. This will be ratified next week and we will send the appellant a letter. Thank you.
Madam Chair, just point of clarification, what would be the next, I guess asking Mr. Riccardi.
The
what
next
is
step.
next step in this process to get this illegal fence removed?
Okay, Mr. Riccardi, can you respond to that inquiry?
Well, I'll send an email to the inspector in the area that the variance was denied.
Thank you, Mr. Riccardi. To the appellant, you will be having a visit from, as Mr. Riccardi indicated, there will be a building inspector dispatched to your property to look at the fence. I would encourage you to make necessary changes so that you come within code compliance. Thank you. Thanks, gentlemen. All right. Moving along to calendar number 23-173.
Next case is calendar number 23-173. This is at 1772 West 50th Street. Dan Barson, owner, proposes to erect a two-story frame single-family residence with in-law suite on second floor above, I may be reading that wrong. Dan Barson, owner, proposes to erect a two-story frame single-family residence in-law suite on second floor above a two-car garage in a B12 family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 5, with city planning approval required for the issuance of a building permit noted. And with that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Holder. I will administer the oath to both of you. If there's anyone online, I will do the same. After I state the oath, please reply with I do, your name, and your address. You raise your hand. Do you swear or affirm that the testimony you are about to give is the whole truth and that is not the truth?
I do. Anthony Cusia, Cleveland Custom Builders, 12025 Schreiber Road, Valley View.
Okay, can you just spell your last name for me?
Kucia.
Thank you.
I do. Daniel C. Barson, 615 10th Avenue Northeast, Apartment 5, St. Petersburg, Florida.
Is there anyone online who wishes to speak in this matter? You, Madam Chair.
All right, thank you. Mr. Cusia, could you tell me the company you represent again?
Cleveland Custom Builders
Thank you.
and Remodeling LLC.
All right, excellent. Could I have the history of the property, please?
Thank you, Madam Chair. There's been no change in the zoning since 1929. There are no variances on file and nothing of note in the more recent history or in our records administration office. Thank you.
Legal standard, please.
Madam Chair, members of the board, appellant is requesting area variances from minimum lot width, minimum floor area, maximum gross floor area, required rear yard, interior side yard, minimum distance between main buildings and adjacent lot, and minimum distance between main buildings and in-laws requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and then granting variances will not be contrary to the purpose and intent of the zoning code.
Thank you. All right, Mr. Cusia, are you going to be the spokesperson or?
I will.
You've got 5 variances, so if you'd like to focus your comments on those items.
So we're proposing a distance between the structures of 17 feet, 17.08 feet. The verbiage in the letter is slightly different than the proposal. So the south property line, we're looking for 1 foot off the property line. The western property line, we're looking for 3 foot. And the northern property line, we're looking for 3 foot. Mr. Barson does live in the home. His legal address is Florida, but he does live there. When he purchased the home, there was actually a garage pad poured for a garage in a previous permit that was pulled. And the garage was actually on the property line. I should say the garage footers.
The footers.
And the floor were poured and they were on the property line. The southern property line and the western property line. There was an issue with that permit that from the previous builder, and that garage floor, due to some issues in how it was poured improperly, was removed by the previous contractor. So now it sits, as we show, with just a concrete pad without any footers or slab that's there. So we're proposing to slide it over the 1 foot and pull it 3 foot to the east and keep it 3 foot from the northern property line. On the drawings, it shows that the 3 sides of the structure will be fire rated accordingly.
Okay. And what's your finishing material on the outside?
It'll be a cementatious board product.
So using like a hardy board?
Correct.
Okay. All right.
So can you go back? Sorry. You said the slab is gone now?
Yeah, that whole slab was poured improperly by the previous contractor.
Okay, so it's out.
Yeah, it was removed by the contractor.
Has the lot been professionally surveyed and pinned?
Yeah, that's part of the topo that's supplied by Aztec Engineering.
Okay. Do I have that topo?
Right there.
All right. Okay, I do. All right. Okay, go ahead.
So that clarifies the different lot requests in regards to the setbacks, and then the setback from the home. Let's, the floor area, obviously the first level. Do you want to go to the drawings, please? So be the entry. So the top of the page is the southern property line. So again, pull straight in to the 2-car attached portion of the project, and then create a stairwell that gets you up above for the in-law suite. In keeping with the design of the structure, we're matching it with a reverse gable.
All right.
So it matches the current home.
The house.
We
All
had
right.
we had several iterations with the architect in order to more appropriate the scheme and the historic gable design.
Okay. Are there gonna be I'm just looking at it there. Your head was in the way.
Oh.
All right. So no dormers,
No,
and it looks like a fairly shallow pitch on that.
correct. We wanted to keep it in line with.
So you had the height.
Correct.
Great. All right. All right.
I'd be curious to know what's on either side of the proposed garage in terms of your neighbors. Like, does it sit really close to the structures they have already erected?
No, the only, let me reiterate that. You can see the, that's the neighbor to the west. So that's where we're proposing to move it, so it's 3 foot from that property line for appropriateness. You can see that's a big side yard, just east of that structure. You can't see the home itself as you go southbound, but that's a huge side yard where we're proposing the 1 foot.
Okay.
Side setback. And then you can see there's just a fence, to the neighbor to the north, which is to the left of our picture. And I believe isn't that a rental?
That is a rental,
Yeah.
yes.
I was gonna ask a follow-up question. Have you spoken to your neighbors about what you're building?
Well, we've actually had a block club,
Right.
where everyone came, to get, their 2 cents. And it was unanimously approved through the block club, which actually the board chair lives right on 50th. So anyone had questions, they walked over, they saw.
Which block club is that? Do you know? Was it facilitated through the CDC?
It was, Michael Rastetter is the chair of the
Okay.
block club. I don't know the exact name, I apologize.
Okay.
But they gave us approval.
Well, that's very good. Thank you for sharing it, but that doesn't mean that the neighbors attended that meeting. So my question was really, have you spoken to your neighbors?
The neighbors to the south, yes.
Okay, in which direction was?
That would be to the left of the property. The neighbors to the right, those are owned by an out-of-town investor, and they're currently up for sale.
Thank you.
Okay.
There's three parcels there, I believe, and they're all up for sale as a group.
Owned by the same person?
Yes, out of town.
Yeah. Okay.
We have spoken to the folks that own the house on the corner. That's also for sale. They wouldn't be impacted. They're pretty excited about the possibility of that development.
Okay. So,
And they've got notice also to attend today's.
Oh,
Right.
yes, yeah.
right. So, Mr. Cusia, is there anything else with regard to the variances listed on the agenda?
Well, they're just, as I mentioned, there's some corrections because it's not 0, it's 3 foot, 1 foot, 3 foot
Okay. So,
per the site plan.
reference to number 2, the rear yard
Is proposed to be 3 foot.
is proposed to be 3 feet. Number 3 is the required interior side yard.
So that would be interior side yard. So which side would that be? Is that suggesting?
That's where Madam Chair, that's where the 1 foot is.
Right.
Interior side yard, not the rear. So the appellant stated that he has 1 foot on one side and 3 feet on the other side?
Correct. 1 foot on the south
Right.
boundary, 3 foot on the west boundary, and 3 foot on the north boundary.
Okay. All right.
And again, the driveway, and there was a garage that was in line at a 0 lot line. That was previously done and due to some improper construction that was removed by
Yeah.
previous contractor.
Okay. And tell us what your intended use for the in-law suite is?
We have a lot of family. My partner is the youngest of 15, so.
Wow.
We're downsizing. The house has 1,000 square feet, the main house, so we'd like that flexibility to use it for them
Okay.
predominantly.
All right. So, it will have kitchenette, bathroom,
Correct.
be fully plumbed,
That's correct.
electrical,
That's correct.
We
heating
plan
and
on
cooling.
furnishing it as well.
Okay, heating and cooling. Okay. Any other questions, board?
I just want to confirm, there's an existing curb cut there, right?
Yeah, there's an existing driveway.
Yes.
Brand new driveway.
Okay, thank you.
Okay. Hearing no other questions or comments, I'll entertain a motion, board. Oh, city planning would like to weigh in, sorry.
We're still in city supportive of accessory dwelling units, and increasing density in neighborhoods. However, in this case, I do have some concerns about the 1 foot off the property line. I think if you go out there, you'll see that it's a very dense neighborhood right there. There's a lot of things going on. If you look at the bottom right-hand corner, we have an accessory dwelling unit on a parcel that's on the other street. And that's gonna be between 4 and 5 feet from their use. And that's where they're having 1 foot off the property line. So I think that gets dangerously close to having these two structures crammed into that corner. So that's our concern. Otherwise, I'm supportive of the accessory dwelling unit. We're always, interested in increased density. This is a somewhat small parcel, and it just seems like it's trying to cram too much into this parcel. You can see right here, there is the other accessory dwelling unit, and their accessory dwelling unit is gonna be right here, 1 foot off of this property line, 3 foot off of this property line. So it would be great if we could somehow get 2 more feet on this side so that we're not 1 foot off the property line. I don't know if that, involves making it slightly smaller. I know the 26 by, the dimensions are kind of large for garage. You could be taken down to 22 feet or even 20 feet. So those are our concerns.
This raises a question for me, Madam Chair.
Yes.
It's something I was sort of thinking. What difficulty would you face if you were to reduce the size or even increase the setback of the proposed garage?
Well, I mean, the apartment above naturally would be smaller. I think right now we're at about 580.
572.
572 square feet upstairs for the ADU. That's of some concern, naturally.
So, I'm just looking at the lot width. This is a 30-foot wide lot. Is that right?
May I add something?
Sure.
Okay. So I believe you're talking that north, so the south property line, there's no structure.
There's no structure on the south property line, but there is a structure right here.
Correct.
And you also are written up for being less than 6 feet from a major structure on the adjacent property.
Right.
So it's very tight.
So I think the options we're looking at, right? So we're at 22 deep by 26 wide. So reducing that to even 24 feet would still get you 2-car garage and would increase your setback. Or, well, I don't really think you have the opportunity to slide it one way or the other. Reducing the size slightly is the only option. If we went to 24 wide,
Yeah, then you pick up the extra 2 feet, you would not need any variance.
Right.
Well, remember, you have the steps to get to the
Right.
second floor. I mean, I don't know dimensions, but remember that.
Yeah.
yeah, that's true.
What if you pull it closer to your house? I guess you have a deck there.
Right,
We do, yes.
just trying to come up with some options here.
What if we were, I might be speaking, what if we were to reduce it by a foot and then share 2.5 feet? Because it's just, I think the use upstairs becomes,
So if you reduce the width from 26 to 25, is that what
Correct.
you're saying?
correct.
So that would pull it in off of the one side. All right. All right, I think, board, the appellant's, contractor is proposing to reduce the width from 26 to 25 feet. As a condition, should we approve this, we would need new plans submitted for that. And if you have any further questions or comments on that,
What material change does that make?
what material?
Yeah. I
Well,
mean,
so
what-
he's gonna do, you were gonna do an extended fire rating, right?
Correct.
Besides, I mean, the next step up from standard fire rating,
Correct.
correct? And he's gonna do an exterior finish with hardy board, which is cementitious.
Yeah, I'm saying, what's the difference in 1 foot with, you were already doing the additional fire rating?
Right. Well, so that's the other question too.
So it seems to me that reducing it from 26 to 25 doesn't address this portion that's the closest. Am I understanding that right?
No, I think that's where they're giving you the extra foot, it's
Yeah.
right here. They're going that way, is that not right?
Correct. We
Right.
would keep the north and west at 3 foot and then change the south line. The south line, again, is just a fence and it's probably 40 feet to the house.
Oh, sure.
And does the fence go all the way to the back, to the property line?
Yes.
Back corner.
So at 2 feet, can somebody walk in between to do maintenance to the side of your building?
Well, yeah,
I'm sure that's another issue, obviously, is why we have 3 foot minimum, is because you can't really even access the side of the building without going on your neighbor's property, and if there's a fence, you physically cannot get back there. I mean, I think 2 feet barely makes it that you could get in there, but that's the reason why we have the 3 foot minimums in the code. Besides the fire safety issue, it's also even just an access issue.
right.
You can't get in there.
Madam Chair, I have a question for the appellant and or his contractor. Can you please explain to the-
One sec, Ms. Roca. Gentlemen, Ms. Roca has a question for you. So they were conversing, so I wanted to make
Oh.
sure they heard you. Go ahead.
Great, thank you. Gentlemen, can one of you please explain to the board why, what is the difficulty for you in not having the structure be 3 feet on all sides? What is your challenge there?
Well, we lose more space. It's a challenge.
Relative to the dwelling that's above the garage part.
As well as the garage, I mean, both.
Yeah,
So I just follow up to that. So if you were to make it 3 feet on all sides, would you still be able to retain the 2-car garage?
Yes.
So the harm to you and why you're seeking this variance is pretty much solely to have a larger apartment.
he's nodding his head yes.
Yes, and basically, we were following to a degree what was already
What
there.
was already there? Can you cantilever it towards the house, the extra couple of feet? The second floor? Give you area at the top?
Yes, we could.
Go to
So
20
what
and
are,
then-
so what are we looking at, going 22 instead of 24? Would that take care of the issue?
20, go to 24 on the depth and 24 on the width, allowing for 3 foot.
Well, you're at,
Sure.
So from 20
you're
feet,
at, you're at 22 on your depth
correct,
and
but-
26 on your width.
correct. So correct. So take it from 26 to 24,
Right.
which then allows us to have the 3 foot side yards.
All around.
And then take it to 24 in depth, which just requires a little bit of interior manipulation of the space.
So if you're able
Because right
to,
now it's 26 by 22. So what we're saying is
Go to 24 by 24.
24 by 24. Okay.
okay,
And so you take the, Madam Chair, just to be
Yeah.
clear, you take the extra, so you're gonna make it a little deeper. And that would move, that would be 2 foot closer to your house.
Yes.
So you keep the 3 foot. That's,
Right.
that seems like a reasonable compromise.
yeah, I think so. All right. You happy
Yeah.
with that?
Yes.
Okay,
That's a-
'cause
I think
that
that's a
makes-
fair compromise.
That makes all of us happier.
Okay.
Because we can still get the cars in there appropriately.
Right.
Yeah, and I think it will also then give you, you'll have a little bit of space then for, the lawnmower, the bikes, whatever
Right.
else has to live in the front end of the garage
Yes.
rather than on the side.
Right.
Okay,
Madam Chair, I just want to make sure I'm clear. So the width of 26 feet is coming down to 24 and the depth is remaining 22?
it's going to 24,
Okay, so the whole thing's going to be 24 by 24.
correct, right, rather than 26
Yeah, got it.
by 22. So
Thank you.
that will mean that it will extend 2 more feet towards his residence, and that fulfills getting the setbacks correct. Good,
Okay.
good? All
Madam
right,
Chair, I just have one more
I,
question.
yes,
Just for my notes, I just want to make sure, I apologize if I missed it. Is the purpose of the in-law suite personal use, or is the appellant intending on renting it out?
Well, right now it's personal.
Okay, but there
Personal
could,
use.
okay,
yeah,
Family.
yeah. He said it's for the extended family.
okay. Thank you.
All right. Okay, anything else? All right, I see head nodding, always a good sign. I'll take a motion. Anyone?
Yeah.
Madam Chair, oh, go ahead, Ms.
Nope.
Brown.
Having heard the testimony and worked with the appellant to make modifications to the site plan such that the two-frame structure will now have a footprint of 24 by 24, I move approval for use, the proposed second floor residence for family, use. That's it.
We want to include condition of submission of new plans.
Conditional on submission of the amended plans.
Thank you, ma'am.
Thank you.
All right, I'll take a second.
Board Member Roca seconds.
Thank you, Ms. Roca. Ms. Kukla?
Ms. Holzer,
Yes.
Ms. Wilson,
Yes.
Ms. Roca,
Yes.
Ms. Brown,
Yes.
Ms. Bates.
Yes.
Calendar number 23-173 is granted conditionally. We will hold ratification until we receive that updated drawing. Once we receive that, we will ratify it the following Monday and send you a letter.
Thank you so much.
Thank you.
Once the Monday after it's submitted.
Right.
Or, okay,
Well, as soon as you can get the drawings to us,
right.
you know,
Following Monday.
yeah.
So
The
you
fol-
guys need a copy of those from building? Is that
Just submit them to me.
Yeah, just submit them.
electronically?
Yeah,
Okay.
and then I will upload them into the system and
And they'll be.
building and master, right?
Okay,
Right.
okay.
Okay,
And I'll print it out, if you could, yeah, I'll print them out, because this is a paper copy, and we'll print it out and send it over. Well, you'll bring it over, sorry, give us a call.
I'll come to
Next one.
and then take it to 501.
Yeah, the process is
I
a
mean,
little more
505.
complicated, but yeah, give us a call, the following Wednesday after the Monday that we granted. We'll talk.
the following Wednesday after the
Well,
following Monday.
Just give us a call.
Thank you.
Yes.
All right, I'll see you outside. Thank you.
Yeah,
Thank you.
just call Liz.
Yes.
All right. Oh, are you staying with us?
I am.
All right. Did you pack a snack today?
My stomach's eating itself.
Yeah, all right. Okay, Ms. Holzer. We'll conclude our day with calendar number 23-174.
Sure. Our last case is calendar number 23-174. This is at 2901 J Avenue. Greg and Rebecca Wallem Hopt, owners, proposed to construct a two-family dwelling in a B1 two-family residential district. The owners appeal for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 4. There is also a note that city planning approval is required prior to the issuance of a permit, and a lot split is required. And with that, I will hand it over to Ms. Wilson for the oath.
Ms. Holder. I will do the swearing in for this matter. If you plan to speak, please raise your right hand and thank you. Reply with I do, your name and your address. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth?
I do. Anthony Cusia, 12025 Schreiber Road. Cleveland Custom Builders and Remodeling LLC.
Okay, and I'll just have you spell your last name for me.
KUCIA.
Thank you. Is there anyone online who wishes to speak in this matter? It is back to you, Madam Chair.
All right. We don't have any appellants. You're representing them?
Yeah, they both, one's out of town, the other one.
Okay, all right. Did they, have you submitted a letter with their signatures that it's okay for you to represent them?
I believe I did.
Let me check, Madam Chair.
Okay.
I'm not seeing it printed out in the file here. You could resend it to us.
Sure.
All right,
We don't
we'll
have
just need that in the file.
Correct.
All right. Okay, history of the property?
Thank you, Madam Chair. There's been no change in the zoning since 1929. We found in our Records Administration Office that in 1976, a permit was issued to demolish a multifamily dwelling unit at the site. There are no variances on file and nothing of note in the more recent history. Thank you, Madam Chair.
All right, legal standard, please?
Madam Chair, members of the board, appellant is requesting area variances from maximum lot width, required rear yard for irregular shaped lots, and depth of the required rear yard, requirements of the zoning code, and from the conditions for allowing a residence building to be erected in the rear of a main building. To obtain the area variances, appellant must prove that denying the request will create practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting variances will not be contrary to the purpose and intent of the zoning.
Thank you very much. Okay. You're on again.
So I'll start with the last part. We already did receive approval for the lot split. The lot split was already granted and already recorded with the county.
Okay.
I don't understand what the project is. Can you tell me that?
We're building a new home with a detached and suite.
And
So
there's a garage someplace. It looks
the
like.
current garage will be demolished.
Thank you. That part was not clear to me.
Okay.
So there's a new house on the side and a new garage sort of where the old garage is.
Similarly, but smaller, a little bit smaller than the existing garage.
And it's accessed from an alley or something.
That's correct. Wait. The alley is, Waco?
Is that it, Waco?
Yeah.
And this is for sale, rental, family, what?
The current homeowner lives in the existing residence at
Uh-huh.
2905. The new proposed residence, 2901, is they're gonna be their new home. They're gonna be selling the existing home. And they're both from the Dayton area, and so they have a lot of they're getting ready to start a family, and they're gonna have relatives up visiting, and that's the use, proposed use of the in-law suite is actually for the in-laws and or parents.
Okay, so we have two family dwelling.
You wanna keep talking?
Yeah, I
Yeah.
want you to just target the,
Yep.
target your variances on your list there.
So obviously all the lots on the street, I believe, are 33 to 36 feet in width, somewhere in that area. So that's obviously a necessary requirement, just because of the way it was platted. The front yard, side yards of the home meet the necessary requirements. Again, we're trying to hold the 5 feet. Rear yard. I believe that's off the alley. Is that 7.2 is?
You know, I'm not, Chair,
Yeah.
that would be a Rick Ricardo question. I wasn't quite sure with number 2 and number 3, because there were 2 different rear yards that are listed, so I wasn't
Right.
sure what that meant.
Mr. Riccardi, can you share some insight on that?
I think it is just boilerplate language. Uh, I think that the correct one is number 3, because as you see, 1 and 2 is citing the same code section, 35504.
Right.
And I also think that it's talking about the minimums. So the correct standard is in number 3. That the required rear yard has to be, it can't be less than the height of the main building. And therefore is 24 feet is required.
Madam Chair, it looks like the rear yard between the proposed new garage and the residence is 26 or 25 feet. So does that mean number 4 is not?
Right.
Yes, well, the correct standard is half the height of the building. So, you know, what is placed on the docket here, 2 can be ignored and 3 should be read as less than half the height of the main building.
All right, so we can delete number 2 and number 3 is,
Madam Chair, to the applicant, what is the height of the main building?
The average height, if you go to the slide, I can't recall. So the average, I think we call it out like 29. So I think that's just the front gable is just the higher point, but the average is somewhere around 29 feet.
So half of 29.
Right, because you've got the average.
yeah,
Less than the 25 we have.
So does that mean that number 3 is also not needed?
It sounds like it to me.
right. Would you say that's correct, Mr. Riccardi? Number 3 is not needed. The height's 29.
And what is the rear yard that is requested? Or that is shown?
25'10".
Did you hear that?
So we are talking about the residence isn't going to be in the new garage?
Is
There
there,
is
garage
one
is detached.
above.
but is there a residence above the garage?
Yes.
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 An in-law suite above the garage.
Maybe that's the one he's
That's-
talking
yeah.
about.
It looks to me like, I could be wrong, it looks like the rear yard that's being proposed is 5 feet.
That's the apron to get into the garage.
Yeah, that's from
Garage in-law
the
suite.
second floor suite. That's what he's writing the variance on.
Right.
Okay. We'll do this.
I mean,
All right.
from the plan that is up now, the proposed new garage, I'm seeing a dimension of 5 feet.
He's right.
Right.
So Madam Chair, through to the appellant, you mentioned a parking drive apron. I'm sorry, did I miss it? Is there an alley behind this?
There's an alley
Yeah.
behind, yeah.
With-
And so that's where so the 20 feet, 4 feet would be required off of the alley?
Yeah,
So the green.
So the current,
it wouldn't be that.
the current garage is approximately 5 feet from the alley.
How tall is that building gonna be? Not the primary house. We were measuring the wrong one. Go back to the height, please. And he doesn't have
You gotta
it
keep,
here.
you gotta keep going over.
There you
There
go.
you
How tall
There
is
we
that?
go.
I think it's 24, but the average is like 22.
22. So it's
Yeah.
11 instead of 5.
Yeah,
There you go. I think that's what, you're right, that was the,
right.
it
'Cause
was the main, it was the accessory structure instead
Exactly,
of the main, okay.
right. And it's tiny print, but it is 24 on the garage is your
Right.
height. Yeah. Okay. All right, we all clear?
Yeah.
Okay, awesome.
Madam Chair, I'm sorry, I missed where the 11 came from. That's taking half of the alley, is that what we're speaking of?
We're talking about the height it needs to be, half the height, which was 24, so I was rounding.
Right.
Somehow, we were looking at different numbers, but use 24, takes you to 12. And they're offering 5 into the alley. Is there any concerns about pulling directly into the alley? Is the 5 feet distance enough?
That's all right.
Pulling directly out into the alley, is the
Right.
5 feet enough space?
Is
I
that
can't
alley,
remember.
is that a 12-foot alley?
Madam Chair, I could not tell you what the dimensions of the alley are.
The current garage is 5 feet. That's what we based it on,
Okay,
because they're able to come in and out.
And that's what they use now?
That's what they
Okay.
use now.
Mhm.
all right. So then,
So it's almost an existing condition.
yeah, it's just taller. Yeah.
Correct.
Okay. All right, any other questions or comments? Would you like to weigh in any further, Mr. Williams?
So we would recommend approval after all these clarifications.
Okay.
We did have a letter.
Oh, we did have a letter, okay.
Or opposition letter.
Okay.
From Bart Coster. He states, he does give his address as 2905 J, so he's very close by. He states that this is a long email, so I did some summarizing.
Yeah.
He tries not to make negative inferences from possible oversights, but in aggregate with several other factors, he has a creeping suspicion that this variance is a foregone conclusion and his efforts to attend might be pointless. He says he has a vested interest in the neighborhood since 1992. The neighborhood has a certain charm and look that makes it uniquely attractive amongst Ohio City's many attractions. His interest is in preserving the character of the street as well as protecting his own investment. He sees no point in constructing a double and requiring a variance from the 50-foot frontage to the proposed 36. He would maintain that if a single would be allowed to be built on the site, as there once was that existed there, that it should be limited to such if only it can be done within the current legal zoning ordinance size requirements that the rest of the property owners are legally bound to respect. And he states that while times have changed and for the motivations, it's not necessarily the job of the zoning commission to make everyone's dreams come true. Thank you.
Madam Chair, one thing I'd like
Yes.
to mention is that this is in a landmark district and it was approved by the Landmarks Commission. It is on.
That is good to know, Mr. Billings. Thank you. All right. Any other questions or comments, board? I think we've covered everything. So I'll entertain a motion. Ms. Wilson, you want to take this one?
Yes, Madam Chair. So
All right.
based on the testimony that we have heard, I would move to approve calendar number 23-174.
Could I have a second, please?
Member Brown, I second.
Thank you, Ms. Brown. Ms. Kukla?
Madam Chair, and this is of course stating that we're only approving numbers 1, 3, and 4 as section 355.04A is no longer relevant.
That is correct. Thank you.
Thank you. Ms. Olter,
Yes.
Ms. Ronka,
Yes.
Ms. Wilson,
Yes.
Ms. Brown,
Yes.
Ms. Bates.
Yes.
Calendar number 23-174 is granted. It'll be ratified next week and we will send the appellant a letter. Please feel free to contact our office next Wednesday for further instruction.
Great, thank you so much.
Thanks.
Thanks for spending the morning with us
Thank you.
and good luck on the projects.
Thank you very much.
All right.
It's not a
Where is my old business sheet?
should be in the,
Oh, I know, I have it. It's all I have. There we go.
you got it.
All right, old business. We have numbers 1, 2, and 3. Without objection, board?
No objection.
No objection.
All right. Excellent. And you want to tell us what this note, the
This
affirmation is?
BZA number 23-051 at 1422 West 54th Street. Barbara Lance was granted variances to erect a 2-story single-family residence on April 24th, 2023. The appellant has requested an affirmation to allow for 6 more months because the appellant needs more time to complete the land bank application for the land that will make up the rest of the parcel in order to complete the project.
Okay, without objection, board?
No objection.
No objection.
Objection.
Okay, thanks very much. Anybody have anything else?
That's it.
All right. We are adjourned.
Thank you.
Thanks, everybody.